Welcome to HIPAA Employee Training.
It is imperative for all employees to receive continual HIPAA training, once during new hire orientation and again on a regular basis to account for any changes to company policy or the law. This is to remind everybody of their responsibility for the confidentiality and security of information reviewed within the organization. At the end of this training, you must also complete and sign an acknowledgement of training and the information that was covered in this presentation. This presentation will cover HIPAA and its applicability to us as members of the workforce. We will delve deeper into the HIPAA privacy and security rules, paying special attention to the security safeguards. Next, we will cover HIPAA violations and breaches. Then we will go through real-life examples of HIPAA violations and conclude with useful tips for complying with HIPAA. Let's go over a brief overview of HIPAA. HIPAA stands for the Health Insurance Portability and Accountability Act. It has since been amended in 2009 by the HITECH Act and again in 2013 to further protect medical information in electronic format. It also increases penalty amounts and spreads the responsibility of compliance to business associates and their subcontractors who handle medical information on behalf of covered entities. One of the most important things to know about HIPAA before moving forward is the definition of PHI. PHI stands for Protected Health Information, and it is any individually identifiable information created or received by a covered entity that can reasonably identify the individual and also relates to the past, present, or future physical or mental health or condition of an individual, regardless of the media form that it is or was stored. We will be referring to this acronym often throughout this presentation. There are two main areas of focus for HIPAA as it relates to most of our job duties here at the organization. These main areas of focus are privacy and security. Privacy is the usage and disclosure of protected health information, whereas security deals with the protection, confidentiality, and storage of protected health information. How does HIPAA apply to our organization? Ask yourself through these next few slides if the organization can be categorized in any of the following, either as a covered entity, a business associate, or a subcontractor. A covered entity is defined under HIPAA as either a health plan, a healthcare clearinghouse, or a healthcare provider who transmits any health information in electronic form in connection with a transaction covered by HIPAA. Examples of healthcare providers would be, but are not limited to, doctors, medical clinics, psychologists, dentists, chiropractors, nursing homes, or pharmacies if they transmit information in electronic form. A business associate is defined under HIPAA as a person who is not a member of the covered entity's workforce and arranges, creates, receives, maintains, or transmits PHI, or provides legal, actuarial, accounting, consulting, data, aggregation, management, administration, accreditation, or financial services to or for such covered entity, and where the services involve the disclosure of PHI. A common arrangement is one where law firms are categorized as business associates under HIPAA because they transmit, disclose, receive, or maintain PHI in the course of representing a covered entity or a business associate. For example, a law firm may use PHI when creating and executing medical authorizations or subpoenas to obtain medical records. Also, a law firm may use PHI when they transmit medical records to an expert witness. Another arrangement where insurance companies would be considered business associates would be in medical malpractice cases, because this is where the workforce would transmit, disclose, receive, or maintain protected health information in the course of representing a covered entity or another business associate as their insured. For example, a claims adjuster would come into contact with PHI if they were getting medical records to evaluate a certain case. What is a subcontractor? A subcontractor is defined under HIPAA as one that creates, receives, maintains, or transmits protected health information on behalf of the business associate. Subcontractors are also defined as business associates under HIPAA. Examples of a subcontractor would be support services. Support services are those that assist the business associate in maintaining, transmitting, disposing, or storing protected health information. Examples would be a records retrieval company, a court reporting company, a record disposal company, a copy machine vendor, or an IT department that is outsourced outside of a company. Here we can see the parties covered under HIPAA lined up with their corresponding examples. Based on this diagram, would you be able to now know what your organization can be categorized as? The company as a whole is a subcontractor. As a subcontractor, the organization is subject to HIPAA and is obligated by law to have all data treated as confidential and only used for business purposes. As a member of the workforce, we are obligated to comply with the organization's privacy and security policies and procedures. Why comply with HIPAA? HIPAA is the law, and in complying with HIPAA, we show our commitment to protecting privacy and our reputation. We also do so to build trust between our company and our clientele. In dealing with protected health information, we are handling one of the most private pieces of individuals' information. Our clients place their trust in us to preserve the privacy of individuals' sensitive and private information. If you choose not to comply with HIPAA, you can subject yourself to company sanctions, legal penalties, risk to your financial future and/or your reputation. There may be other laws in addition to HIPAA that the organization must follow. For example, there may be state laws that have guidelines on medical privacy that are stricter than HIPAA. There may also be state laws that instruct on maintaining the privacy of other types of personal information not covered by HIPAA, such as driver's license information. Like HIPAA, state laws may impose penalties for failing to follow their laws and are written for the punishments to apply on top of any penalties that HIPAA levies upon the violator. Now on to HIPAA privacy and security. Let's revisit PHI here. Here are the nuances to note. PHI is information created or received by a covered entity. This means that if it did not come from or go to a covered entity, it is not PHI. Also, PHI in any form must be protected. This means electronic data, hard copies of medical records, or medical information spoken by a covered entity's personnel is protected health information as well. On to the HIPAA privacy rule. HIPAA spells out in its privacy rule the ways PHI may be used or disclosed, and it is interpreted that any use that surpasses the privacy rule violates HIPAA. PHI may be used or disclosed to individuals who provide a signed authorization, thereby consenting to the release of their PHI. PHI may also be used or disclosed as required by law. An attorney or court clerk may issue a subpoena, or a court may order that PHI be used or disclosed. PHI may also be used or disclosed if it is subject to incidental use or disclosure, meaning that if your job duties do require you to use or disclose PHI, it may be allowed under HIPAA. Lastly, PHI may be used or disclosed if the Department of Health and Human Services is conducting an investigation and is requiring access to PHI. One of the methods of lawful disclosure of PHI would be through an authorization. An authorization is a document that gives permission to disclose an individual's protected health information, or PHI. You may have encountered an authorization yourself whenever the doctor's office required you to sign a document when you wanted a copy of your own medical records. Now, authorizations are more detailed than ordinary consent. HIPAA requires that an authorization include the following, and mind you, this is not a complete list of everything that is required. An authorization is supposed to include the patient's name, a description of the PHI in a specific and meaningful fashion, the purpose of the disclosure of the PHI, who the intended recipients are, an expiration date of the permission to disclose this PHI, as well as the person authorized to make the use or disclosure of this PHI. One quick way to determine if the authorization is valid or not is to see if the authorization has a valid signature. The signature must be that of the authorizing person or their guardian or their power of attorney. The HIPAA security rule intends to ensure that security safeguards are adopted to protect PHI which may be at risk. These safeguards are further categorized as administrative, technical, and physical safeguards. When adopting safeguards, it is done on a reasonable and appropriate standard. To explain, do we need to follow the highest standard or need the most expensive security that is out there? Not necessarily. Entities of different sizes are required to follow HIPAA, and the reasonable and appropriate standard allows every entity to adopt safeguards that make sense for them given their size and the complexity of their operations.
Here is a list of HIPAA administrative safeguards. Under HIPAA, it is required for a company to conduct a risk analysis on a regular basis and to have a plan for managing that risk as well as a sanction policy for anybody who violates HIPAA.
One administrative safeguard that applies to most of our job duties is the set of company policies and procedures regarding internet and email use. These company policies, for example, instruct you to access only trusted, approved sites, also tells you that your workstation will prevent you from downloading programs without permission. Your policy also tells you to use work emails for work purposes only, and to not open email or attachments if you are suspicious or don't know the sender.
Here is a list of HIPAA physical safeguards, which limit physical access to a company's facilities where PHI is to be found, while ensuring that authorized access is still allowed.
Examples of physical safeguards that may exist around the organization are listed here. For example, most employees would be assigned a badge that controls his or her areas of access around the building. Also, the organization may have office buildings equipped with business security systems which will arm the premises while nobody is occupying them. Proper disposal may be facilitated by designated areas in which to put PHI for shredding, destruction, or other proper disposal methods under HIPAA.
And here is a list of HIPAA technical safeguards. Although encryption and decryption is an addressable safeguard and therefore not required of all organizations, it is a highly recommended practice. Though it may not be within the organization's power to prevent the theft of every single electronic device, it is well within their power to encrypt.
Password management is a part of maintaining unique user identification, which in turn satisfies one of the HIPAA technical safeguards. In periodically changing your password and making it unavailable to others, you are helping to ensure that you indeed are the one person who is logging in and accessing PHI.
And as mentioned in the previous slide, any portable devices used for the job outside of the workplace must have security and encryption.
There are 3 entities that enforce HIPAA on a statutory basis. The Office of Civil Rights within the Department of Health and Human Services investigates HIPAA complaints and may also conduct compliance reviews. If possible criminal activity or civil wrongdoing is suspected, the Department of Justice may accept the case and pursue it to the fullest extent of the law. A state's attorney general may enforce HIPAA violations by pursuing private civil actions. Here are the civil penalties levied by the Department of Justice for HIPAA violations. For violations occurring prior to February 18, 2009, the penalty amount is up to $100 per violation, but up to no more than $25,000 within a calendar year. For violations occurring on or after February 18, 2009, it can range up to $100 per violation to $50,000, but no more than up to $1.5 million within the calendar year. The Department of Justice also levies criminal penalties for HIPAA violations. If you didn't know or were found to have reasonable cause for the violation, you could be fined up to $50,000 and up to 1 year in prison. If you are found to have known of the violation and then lied about it, it's $100,000 fine and 5 years in prison. If you are found to have violated HIPAA for personal gain or for malicious reasons, then the penalty increases up to $250,000 and up to 10 years in prison. HIPAA violations. How do HIPAA violations happen? They can happen by disclosing PHI-related material to the wrong client, or by improper disposal of records. by mailing records to the wrong address, or transposing work order numbers in emails or the company system. This goes to show that HIPAA violations can happen out of mere carelessness. In addition, individuals who maliciously use or disclose PHI will be subject to the following. They can be subject to company sanctions up to and including termination. Such individuals will be held personally liable both civilly and criminally, and all information, including the name of the responsible party, will be provided to the Office of Civil Rights for their investigation and subsequent prosecution. It is important that we report HIPAA violations real or suspected within the company so that they can be investigated, managed, and documented, and you can also help prevent the same violation from occurring in the future. Also, immediate reporting of HIPAA violations can help minimize risk and damages of further unauthorized disclosure of PHI. How do you report possible violations or concerns? If you see or think you may be involved in a possible HIPAA violation, report it immediately to your supervisor, manager, or the compliance officer. After consulting with the compliance officer, it may be determined that a breach assessment may need to be filled out, which will require your cooperation. A HIPAA breach assessment is a necessary step in complying with HIPAA whenever a breach has occurred or is suspected to have occurred. It involves a gathering of information on the part of any on-TELUS employee who knew of the violation together with their manager and then documenting it. This completed paperwork enables the HIPAA compliance officer to demonstrate with legal analysis in determining whether the breach must be reported to the Department of Health and Human Services in compliance with HIPAA. This also fulfills a HIPAA requirement to keep written record of these incidents in case of future investigations by the Department of Health and Human Services. In the event a breach assessment needs to be completed, here is what it looks like. It will ask you for the name of the person completing the form, the date of incident, and if different from the date of incident, the date when the incident was detected by the company, a brief summary of what took place, if PHI was involved, and whether that PHI was secured or not. As you can see, the language can get hyper-technical and complicated. As an employee, you will not be asked to fill this out alone, but together with the manager in charge of the assessment, you will be responsible for fact gathering. This means you will be required to provide as much detail and gather as much evidence to the best of your personal knowledge. Therefore, employees with first-hand knowledge of the incident are obligated to provide such information and should not pass this duty on to anybody else. Since this is an official HIPAA document, it requires signatures from the managers and directors who completed the assessment together with the HIPAA compliance officer's stamp. Let's cover HIPAA breaches of unsecured protected health information. HIPAA defines a breach as the acquisition, access, use, or disclosure of protected health information in a manner not permitted by HIPAA, which compromises the security or privacy of the protected health information. What is the difference between a breach and a HIPAA violation? A HIPAA breach must be reported to the Department of Health and Human Services unless the organization can prove that there was a low probability that PHI was compromised. HIPAA violations, on the other hand, happen incidentally, accidentally, or purposely, but the violations that are reported and effectively addressed can and may be stopped before it ripens into a breach. Every step taken to address a HIPAA violation counts. Here are real-life cautionary tales. On March 22, 2018, Med Associates became aware of a breach and proceeded out of an abundance of caution to notify all affected patients, notify the media, and sent a breach report to the HHS on June 14, 2018. Med Associates became aware of unusual activity on an employee's workstation, later discovering that an unauthorized party hacked into the workstation. Upon discovering the unusual activity, Med Associates immediately cut off the affected workstation's access to the company's servers and PHI in possession. The takeaway from this story is that it is impossible to guard against all HIPAA violations, but any efforts to act fast and act out of an abundance of caution are rewarded. It is likely that Med Associates was able to avoid any additional penalties. Middletown Medical took quick action to review and revise its policies and procedures, employee training, as well as its technical safeguards after discovering that the radiology interface may have permitted users to see a patient listing and even allowed unauthorized users to access EPHI belonging up to 63,551 individuals. All potentially affected patients were notified by mail, offered 1 free year of identity protection services, and encouraged to monitor their medical benefit statements. In January 2018, Middletown Medical briefly misconfigured a security setting on their radiology equipment, which created an open portal for just a few hours. As a result, the data breach summary submitted to the OCR indicates that up to 63,551 patients had their PHI potentially exposed, including the names of the patients, birth dates, client identification numbers, and information about receiving radiological services. Now, even though it wasn't confirmed that PHI was actually misused, the HHS does consider this a breach, even though it was a potential disclosure. Pulse Systems, a HIPAA business associate, had to report the breach to their respective covered entity, Lincoln Pulmonary and Critical Care, which then provided breach notification to the HHS and affected individuals. The business associate also improved their technical safeguards and technology to ensure the mistake does not happen again. On July 27, 2018, Pulse Systems issued a notice of HIPAA breach announcing that the PHI of 722 patients was impermissibly disclosed through a mix-up of medical billing statements being mailed to the wrong patients. The medical billing statements contained patients' names as well as the procedures they underwent and were being billed for. This is something that you can imagine happening at Ontellus. It is important to take precautions before PHI leaves Ontellus. The University of Texas MD Anderson Cancer Center in Houston was ordered to pay $4,348,000 in civil penalties for HIPAA violations related to the organization's encryption policies and subsequent failure to take remedial action. MD Anderson had 3 data breach reports dating as far back as 2012 and 2013 involving the theft of an unencrypted laptop and the loss of 2 unencrypted flash drives containing unsecured EPHI belonging to more than 33,500 individuals. MD Anderson insists that it was not obligated to encrypt their devices and argues the $4.3 million penalty amount is unreasonable. Yet the OCR investigation revealed that MD Anderson did not adopt its 2006 encryption policies until 2011 and still did not encrypt its devices with EPHI from 2011 to 2013. There are a lot of takeaways from this story. Number 1 is to encrypt your devices. Even though it was mentioned earlier in this presentation, it was an addressable safeguard. It might as well be required because it could save millions of dollars in penalties. Also, do not sweep HIPAA violations under the rug. It can come back to haunt years from now. Useful tips. Here are some useful tips for complying with HIPAA. Primarily, review and follow the rules in your employee handbook. It will reiterate many other HIPAA guidelines. Generally access and disclose records or claimant information on only a need-to-know basis. Lock your computer and follow proper login procedures. Do not add software nor change or delete any that the company provided in your workstation. Be on the lookout for any lost, stolen, or compromised electronic devices and report such immediately. Do not store PHI on mobile devices unless authorized and properly safeguarded. Do not release PHI to the media or individuals who offer to pay for the PHI. Doing so would be grounds for disciplinary action. Thank you for completing the HIPAA employee training. Please report to your immediate supervisor that you have completed this training. You will also be given a quiz on this presentation as well. If you'd like more information or have any questions on this presentation, you may contact the legal department at legal@ontellus.com.